Good afternoon, and welcome to today's webinar on the key immigration law cases from the year so far, with Adam Pipe from No.8 Chambers. Adam is a barrister specialising in immigration, asylum, and human rights law, and is ranked by Chambers and Partners for immigration law in the Midlands. Adam provides regular updates on the law at training events and on social media. For those who haven't joined our webinars before, my name is Finn, and I'm a Junior Compliance Officer at DG Legal. The slides from today's presentation will be sent over tomorrow, and a recording of the webinar will be available for 3 months. So if we do run over or you need to leave, you'll be able to watch the rest at a time of your choosing. We are in webinar mode, so we can't see or hear any of you. So please use the Q&A function if you have any questions. However, we may not have time for this as it's a fast-paced webinar as it is, and Adam has a lot to get through. So we'll see if we have time at the end. That's all from me. Over to you, Adam.
Brilliant. Thank you, Finn. And thank you so much for everybody for joining us today. We've had over 700 people sign up for this webinar, which is always amazes me that hundreds of people want to come and hear about immigration case law. And hello to everybody, and specific hello to those who've said hello in the chat. Great to see some familiar names and some new names there. We're going to look at some of the key immigration law cases from the year so far. I'm going to cover a wide range of topics. Some of it may be covered by your practice, others not. So we're going to look at some sponsor license cases. We're going to look at some protection cases. We're going to delve into Article 8. We're going to look at deprivation of citizenship, revocation of deportation orders, a bit of nationality, and a sprinkling of Upper Tribunal reported cases to finish. So hold on to your hats. We'll go through it. And as Finn said, the recording will be available and you'll be able to access that and go through in a bit more time any cases that specifically relate to you. For those of you who haven't heard one of my webinars or I haven't met before, my name's Adam. I'm a barrister specialising in immigration law. I'm based here in Birmingham, but I practice across the country. Here's the link. What I often get questions afterwards is to get the slides or to get the recording. Here's the link. It's the DG link that advertises this webinar. And on that link, they'll post the video and they'll post the slides. The other thing that's on that link is an ability to donate to one of DG's chosen charities. DG don't charge for these webinars. I don't charge for these webinars. It would be amazing. There's hundreds of us, as I said, over 700 registered for the webinar today. If everybody donated a couple of quid, we could make a huge positive difference as a result of this webinar. Can I just thank Finn and David and everybody at DG for hosting me today. DG can help you obtain authorization to open a law firm, achieve accreditation, deal with complaints or GDPR, respond to the SRA, gain accreditation in directories or increase the number of clients. And if that's something that's of interest to you, do reach out to DG following today's webinar. Just one final thing before we get into the material is for my free resources. Grab your phones out, scan this QR code, and that'll take you to my links. A couple of things just to highlight. The most recent video I did was a discussion with a well-known immigration solicitor, and we discussed the new statement of changes to the immigration rules, the first statement of 2025. So if you've not gone through that, go there, access that video. Some upcoming training events where I'll go through this material in more depth and over more time. So you can sign up to those live in-person events. I know in May, I'm in both London and Birmingham. So it'd be great to see people in person where we can talk about all these things together. And just finally on that link, if you want to keep up to date with immigration law, or get material you can use on your website, in your advertising and your marketing to keep your clients up to date. There's publicly accessible Telegram and WhatsApp channels where I provide often daily immigration law updates that are broadcast there. So you can just use those links to sign up to the Telegram or the WhatsApp channel. I hope that's helpful to you. Let's start with sponsor license cases. I've called it care homes, contracts, and conducting a global assessment. Sorry, I love a bit of alliteration. It's the Welshman in me. So let's have a look at some sponsor license cases. And the first case, actually, I'm cheating a bit in this case because this is a case from last year. But I wanted to flag it up to you because it's a helpful case. It's not a revocation decision, but it's a challenge to a refusal to issue some defined causes. This involved Hartford Care Group. So a lot of these now are care home cases. Hartford are a successful company, and I think at that time they ran 19 care homes. Now, as we know, a lot of attention has been given, even in the new statement of changes, actually, to the immigration rules. Check out that video that I've done, to care workers. Let's track back to December 2023, and we have the former Conservative government announcing the end of care workers being able to bring dependents from March 2024. Now, Hartford Care Group were quite savvy, and they decided to recruit, and this was in relation to 70 DCOSs, before the changes came into force. So they were going to try and recruit before that came into force. And they, in fact, took a recruiting trip to Sri Lanka and then made these applications for defined causes. The Secretary of State on the 19th of January 2024 wrote to Hartford Care Group requesting additional information, and they requested much more additional information that they had done previously. So the judge there cites an example from September 2023 where the claimant had applied for 40 DCOSs, and all they'd asked for at that time was a hierarchy chart. But on this occasion, look at what they asked for. And you can see the bullet points set out there. The particular bullet point that caused the issue in this case is the one that I've highlighted. So what did they ask for? Copies of current official contracts or agreements to demonstrate your business has genuine vacancies related to your request. These should only include contracts which demonstrate a guaranteed agreement to provide services. Contracts which don't confirm specific agreements do not demonstrate a current and genuine vacancy. You must highlight in the contract the relevant clauses which confirm you have genuine agreement for services leading to current roles to fill. If you do not provide contracts with the relevant clauses highlighted, we may reject your request. You can see where this is going. These could be in form of agreements with the NHS, contracts with local councils, or private contract stroke agreements to provide care or other agreements. They must include a clear description of the scope of the service to be delivered. For example, the start and end date of the agreement, the nature of the service provided under the agreement, the number of service users covered by the agreement, the number of staff required to service the agreement, and the locations that the staff will undertake the work. Please note, we will not accept evidence of your business currently bidding for contracts. Your business must already be in a position where it will have sufficient work to employ sponsored workers on a full-time basis. And they require the other bullet points. Subsequent to this, information was provided by the claimant, but the defendant, the Secretary of State, refused the application on the basis that the required information had not been provided, and therefore they didn't think they were genuine vacancies. And one of the issues was, or the principal issue was, the contracts. The judge says this: the defendant denies that it imposed a new requirement to provide contracts. I do not accept that on the evidence. Indeed, the defendant asked the claimant to provide copies of current official contracts or agreements, which should only include contracts which demonstrate a guaranteed agreement to provide services. The defendant made clear that contracts which did not confirm specific agreements, i.e. framework contracts, would not be sufficient. And it was framework contracts that had been provided by Hertford. So they wouldn't be sufficient to demonstrate a current and genuine vacancy. That is consistent with the evidence of Professor Green. So I think he's from the Care Quality Commission. He gave evidence, and they also relied on the Chief Inspector of Borders and Immigration, David Neal's report. In the circumstances, paragraph 16, I accept the claimant's evidence that framework contracts are standard within the care sector, and that there are no standard contracts containing the specific clauses that the defendant required the claimant to provide in the request. So effectively, the Secretary of State was requiring something that doesn't really exist in the sector. I accept that standard contracts in the care sector do not, I think that should be specified. There's a typo in the judgment, specify staffing levels, but refer to and rely on the duties imposed on care providers by law and regulatory control to ensure sufficient staff are provided. And you'll see at the start of paragraph 16, the judge explored with counsel for the Secretary of State whether they were able to assist, and they weren't able to assist in saying whether those contracts actually exist within the sector. So the defendant refused this. They said, well, the framework contracts you provided are not adequate. Now, the judge accepted what the defendant said, that there was not a new policy, but there was a evolving understanding of how best to assess genuine vacancies in the care sector. The defendant was taking a new approach that in order for the requirement in the immigration rules to be demonstrated, a care provider had to be able to provide confirmed service contracts containing guaranteed work provisions. But the judge found, paragraph 56, where I've highlighted, this approach was irrational and impermissible. It was irrational and Wednesbury unreasonable for the defendant to require care providers to provide contracts with specific requirements for guaranteed hours of work in order to show that the job was genuine. Such contracts did not exist as standard contracts in the care sector. The defendant was requesting evidence that it was impossible for the claimants and others to provide, and which had little or no bearing about whether there was a particular job vacancy within one of their care homes. Interesting, at paragraph 60, the judge also rejects the defendant's submission that current vacancies cannot be based on expected demand. It refers to paragraph C144 of the policy, which says a genuine vacancy is appropriate to the business in the light of its business model, business plan, and scale. That gives the claimant flexibility to have a business model which is not simply reactive to demand for care places. The claimant is not restricted to a business model where it may only recruit once it is faced with having to decline local authority requests for care places. It may quite properly recruit prospectively so that it is ready to meet the expected demand or provide a greater level of care in acute cases, or even so it can grow the business and expand the number of users it is able to accommodate. Such recruitment is for genuine current jobs. The judge found that there was no proper Tameside inquiry. Now, Tameside is a public law case. It's where there's a duty on the defendant to take proper steps to gather the relevant information before reaching a decision. Look at paragraph 65. The defendant should have taken steps to gather relevant information before reaching the decision that the claimant's jobs were not genuine. Had the defendant made any sufficient inquiry of those in the care sector, it would have been immediately clear that it was irrational to take into account the lack of official contracts with guaranteed hours. the guarantee of hours was properly found in the sample employment contract between the claimant and the care worker. That was the evidence which confirmed that the care worker was not being recruited on a 0 hours basis or some other basis which did not guarantee they would have full-time employment. Now, the judge does confirm the defendant is, paragraph 67, entitled to check the DCOS applications of a trusted partner and require additional information such as organisational charts to check vacancy numbers and the contracts of employment to check that it was a full-time job. But it was unlawful to judge whether the vacancies were genuine against the yardstick of whether the claimant had official contracts containing the provisions that were requested, because as we've seen, they simply didn't exist. So a really helpful case there. Let's move now to look at sponsor license revocation challenges. And we've seen, if we look at the statistics, a huge increase in the number of license revocations. And I think this sort of enforcement is part of where the new government is focusing on. And again, a lot of these challenges concern care homes. Now, in previous webinars, I've looked at the line of cases from last year, which looked into whether there needed to be a global assessment of the impact of revocation upon a sponsor, its employees, service users, and the wider community before the Secretary of State revokes. And there was that line of cases. Supporting Care Limited, a deputy judge in the administrative court quashed a decision on the basis that the Secretary of State should carry out a global assessment. But there had been a previous decision, Prestwick Care, where a judge had found no, there was no duty on the Secretary of State to carry out a global assessment. And following that, then there were a number of other cases like New Hope and One Trees Estates, which confirmed there was no duty to carry out a global assessment. Two of these cases were linked up in the Court of Appeal, Prestwick and Supporting Care. And in this case, the Court of Appeal found that Prestwick was correct and the Secretary of State was under no duty to carry out a global assessment before revoking a license. But really interesting is in Supporting Care, they find that even though the judge was wrong about the global assessment, they uphold the quashing of the decision on the basis that it had been procedurally unfair. And there's a reliance on Balajigari principle. So we'll have a look at that, where the Secretary of State alleges dishonesty. So let's have a look at what was found by the Court of Appeal. The Court of Appeal confirmed what was said in perhaps the last of those cases last year, One Trees Estates, by Margaret Oby sitting as a deputy judge. She says this: although the Secretary of State has a residual discretion, in the absence of a particular reason to exercise it, there is no obligation to address or provide reasons for not exercising this residual discretion in individual cases. No such reason was provided in the claimant's written representations. The Secretary of State was required to focus on the impact on the integrity of immigration control and the sponsorship regime, not the consequences for the claimant. The revocation decision and the global assessment issue must be considered in the context of the decision as a whole. The Secretary of State has a responsibility to ensure that registered sponsors comply with the guidance, and stringent use of his powers is important to its overall effectiveness. Therefore, the Secretary of State, having decided that downgrading the claimant's licence as an alternative to revocation would not be appropriate, was not required to assess the impact of revocation on the claimant's business, employees, service users, and the wider social care sector. So the Court of Appeal confirmed the Deputy Judge Oby in the One Trees case was correct to say there was a residual discretion, but the Secretary of State was under no obligation to have regard to the impact of revocation, but it was open to her to do so if she chooses. And there was evidence given from the Home Office from a Mr. McGee that the Secretary of State was aware of the impact that a sponsor license revocation can have on a company, its employees, and the wider community, and took steps to mitigate the consequences of revocation. For example, by informing DSHC of action taken against sponsors to enable the department to identify any risk to the disruption of care provided to service users, and in some cases arranging for visa cancellation action to be paused for a limited period to allow continuity of care until alternative sources of care are arranged. Look what the Court of Appeal confirmed. She was under no obligation to have regard to the impact of revocation before deciding to revoke the licence. And that's confirmed in these paragraphs. I won't go through what they say in drawing from the Friends of the Earth case, but there's under no obligation to consider it. If the Secretary of State does consider it, obviously subject potentially to a Wednesbury challenge. Let's have a look what was found in relation to the supporting care and the fairness argument relying on Balajigari. So effectively, there had been a dishonesty allegation in these cases, that there had been a deliberate exaggeration of the role the sponsored worker was involved in order to facilitate their stay. So that was an allegation of dishonesty. And following the principles in Balajigari, now you'll be well aware Balajigari was with the 3225 refusals for the tier 1 tax discrepancy cases. And it set out the principles of where the Secretary of State did need to put the allegation and allow a claimant to respond to the allegation before making a decision on dishonesty. And in this case, it says, but an allegation of dishonesty in this context, so applying those Balajigari principles into sponsor license refusals, has 4 requirements on investigators. First, as this court stated in Balajigari, dishonesty is a serious allegation carrying with it serious consequences. It is for the Secretary of State to establish on a balance of probabilities that the sponsor acted dishonestly. There is no burden on the sponsor to prove that it did not. Secondly, where the Secretary of State has a suspicion that a sponsor has acted dishonestly, she must indicate clearly to the sponsor that she has that suspicion so the sponsor has a fair opportunity to respond. Thirdly, having received the sponsor's representations in response, the Secretary of State must consider all the circumstances before drawing the inference that the explanation for the discrepancy between the job description in the cause and the role actually being performed by the worker is that the sponsor has deliberately exaggerated her role in order to facilitate her stay in this country. If the Secretary of State has clearly indicated her suspicions in the suspension letter, the sponsor may put forward alternative explanations, which the Secretary of State must consider with other relevant matters. Fourthly, if the Secretary of State draws the inference of dishonesty, she must set out her reasons in the revocation letter. There's no need for the reasons to be lengthy or legalistic, but a sponsor whose license is being revoked because the Secretary of State has concluded is acting dishonesty is entitled to know the reasons for that decision, notwithstanding that the decision is taken on her behalf by relatively junior staff. And in paragraph 37, I haven't included the whole of it, they concluded the requirements of Balajigari were not met in the supporting care case, and therefore they upheld the decision to quash the revocation decision, even though the judge had been wrong on the global assessment point. Let's breathe. We've done the first section. Let's change subject dramatically now and look at deprivation of citizenship. So a lot of you will have been dealing in recent years with far more deprivation of citizenship cases and appeals than you had previously, with the Home Office stepping up action, say, particularly against, say, Albanian nationals who claimed as Kosovans, issues perhaps with Iraqi nationals who claimed to come from the Saddam-controlled Kurdish region and had got exceptional leave, where in fact they were from Soleimania, or perhaps people had falsely claimed to be an unaccompanied minor, as examples. One of the most significant events was the decision of the Supreme Court in the Shamima Begum case, which led to the approach changing in deprivation appeals to, rather than the court deciding issues for themselves, reviewing it on public law principles. That led to reported cases such as Sissery and Chimmy, outlining the steps to be taken in a deprivation of citizenship appeal, but they became far more difficult to succeed in when they were only being reviewed on public law principles. This has gone now to court and challenging really the difference between a section 42 conducive to the public good and section 43 of the BNA, where the allegation is that you've obtained your citizenship on the basis of fraud, false representation, or concealment of a material fact. And the Court of Appeal have held that actually it is for the first tier tribunal to decide for themselves whether there has been fraud, false representation, or a concealment of a material fact. And that then the tribunal can consider more evidence at that stage. And that there is a difference, and you mustn't read across from section 42 to section 43 without qualification, paragraph 48. I should record that there, paragraph 49, that there is some discussion about the burden of proving the statutory preconditions. It is unlikely that much will turn on who has the burden of proof, but I would accept this for the Secretary of State, who is asserting that there was fraud, false representation, or concealment of a material fact, to prove that on the balance of probabilities. So it probably won't make a difference because ultimately it's about assessment, but the burden is on the Secretary of State. When it comes to causation issues, paragraph 50, that is to be reviewed on public law grounds. When it comes to the exercise of discretion, paragraph 51, again, that is to be reviewed on public law grounds. Paragraph 52, in terms of human rights, particularly Article 8 there, again, it's for the FTT to decide that issue, obviously giving due weight to the evaluation and policies of the Secretary of State. So therefore now, Sissery and Chimmy do not represent the correct approach. And the appellant will be able to adduce further evidence, paragraph 53, in relation to that, the assessment of the precedent fact of fraud, false representation, and concealment of a material fact. So the test now is neatly encapsulated in paragraph 54 of the Court of Appeal's judgment. Where there's a dispute, it's for the first tier to find as a fact whether there was fraud, false representation, or concealment of a material fact for the purposes of section 40, subsection 3 of the BNA 1981. Causation is on public law grounds in accordance with paragraph 71 of Begum. Discretion is on public law grounds in accordance with paragraph 71 of Begum. Human rights, it's for the tribunal to carry out the assessment for itself. So when you're drafting your appeal skeleton argument in a deprivation cases, these are the issues that it's going to be for the tribunal to decide. And then when you're making your submissions, it's worth making your submissions on the points and saying, well, on point 1, the Secretary of State hasn't established fraud. There's this evidence. You can take into account further evidence and address that. But this is now the correct approach going forward in deprivation appeals. Let's stay with deprivation, and we'll go to the Supreme Court and look at what is the impact of the withdrawal of a deprivation order. So a Secretary of State makes a deprivation order, but then subsequently withdraws it. What happens in that period when the deprivation order was in place? The Supreme Court finds in this case that if a deprivation order is withdrawn, it is to be treated as having no effect for the purpose of determining an individual's citizenship status in the period from the date of the making of the order until it is withdrawn. This was important because ZA was born during that period when there was a deprivation order in place in relation to parents. The withdrawal of that deprivation order means it had no legal effect, so parents was British, therefore ZA is a British citizen by virtue of E3 status. And look at what they say. They say the status of citizenship is a fundamental status of common law and grounds a common law right of abode in the United Kingdom. This is an important right, and therefore the principle of legality is engaged, meaning that general or ambiguous words in legislation will not readily be interpreted as intended to remove this right. The Supreme Court also, apologies for the small text on this one, also set out some guidance on appeals. And they say that paragraph 34, Parliament has provided right of appeal against a deprivation decision, but on appeal it is common ground that it is for the appellate body, whether the first-tier tribunal or SIAC, to determine for itself whether the ground exists and or whether that would make the person stateless. So again, confirming Chowdhury. And look at paragraph 36. First, it is usual for more information to be available to the appellate body than was available to the Secretary of State when making the deprivation decision. Secondly, in hearing, the appellate body makes its own decision on all facts in evidence before it. It is not restricted to the facts known to the Secretary of State when making the deprivation decision. So what we've done so far, we've looked at sponsor licenses, we've jumped to deprivation of citizenship. Let's jump to protection cases now and look at some issues of country guidance, internal relocation, and revocation of protection status. As you know, the tribunal have country guidance cases in relation to the vast majority of countries we see cases from. Now, whilst that guidance is incapable of covering every conceivable possible scenario, they're a very important starting point and they're to be taken into account and given great weight. And that was what was said by Lord Justice Green in SB Sri Lanka, which built upon SG Iraq. PG is a challenge by the Secretary of State in the Court of Appeal involving a deportation appeal that was allowed on Article 3 grounds. The appellant was convicted with offences of sexual activity concerning teenage boys. And in this case, the Upper Tribunal departed from the country guidance in relation to Sri Lanka and gay men called LH&IP. So let's look at what the Court of Appeal said, and the Court of Appeal allowed the Secretary of State's appeal. The starting point for any consideration of whether PG's deportation as a gay man to Sri Lanka would be contrary to his Article 3 rights was for the Upper Tribunal to ask itself whether it was satisfied on the available evidence that gay people who lived openly in Sri Lanka would be liable to persecution. Furthermore, in considering this question, the Upper Tribunal was required to take the country guidance case of LH&IP into account and follow it unless very strong grounds supported by cogent evidence, so you need very strong grounds supported by cogent evidence, are adduced for justifying their not doing so. Para 58. In relation to this latter issue, not only was the Upper Tribunal required to consider the further evidence which had been placed before it, but it was also necessary for the Upper Tribunal to carry out a careful analysis of whether the evidence which had been considered by the Upper Tribunal in LH&IP in order to be in a position to decide whether there were very strong grounds supported by cogent evidence for not following the country guidance. So what are they saying? If you're going to depart, or if you're going to ask a tribunal to depart from country guidance, you obviously need to show them evidence that postdates a country guidance decision that shows your client is likely to be at risk. But you also need the tribunal to analyse what material was before the tribunal who made the country guidance decision in order to make a proper decision about whether there are strong grounds supported by cogent evidence from departing from the country guidance. And they found in this case that the Upper Tribunal had not done so. At paragraph 49, they set out that in LH and IP, there's a summary of the country material that had been looked at Appendix B to the country guidance. And at paragraph 60, they say this: on my reading of his judgment, beyond a rehearsal of the evidence which has been placed before him on behalf of PG, I'm unable to discern that apart from the reference to the previous lack of prosecutions under the Penal Code, Upper Tribunal Judge Perkins sufficiently analysed the evidence which had been considered by the Upper Tribunal in LH and IP in order to be in a position to properly determine whether the further evidence which had been placed before him on behalf of PG did provide sufficiently strong grounds for departing from the country guidance in that case. They also found that there were not proper reasons in terms of finding that PG was at a real risk of persecution as a gay man on return to Sri Lanka, paragraph 64. And at paragraph 65, they summarise, as was pointed out earlier in the judgment, where it's proposed to seek to depart from country guidance, it is necessary for a careful analysis of what evidence exists beyond that which had already been considered by the UT when giving the guidance. And it is only that evidence which is likely to be necessary to be provided to the tribunal to enable it to determine whether it provides sufficiently strong grounds for not following the guidance. Although to date this has not been the approach adopted on behalf of PG, it is one which should now be adopted. Let's change the subject slightly. Staying within protection claims, let's look at the issue of internal relocation. In the case of ASJ Somalia, ASJ found to be at risk in their home area, but the Upper Tribunal found that he could relocate to Mogadishu. The challenge was on the basis of the way the tribunal had approached the question of internal relocation, and there was issues about burden of proof in relation to that and standard of proof. Lord Justice Lewis said this: there is a danger of over-analysing and over-refining the relevant test. As Lord Bingham observed in relation to questions of internal relocation in AH Sudan at paragraph 5, the difficulty lies in applying the test, not expressing it. The decision maker must decide whether it would be unduly harsh and so unreasonable to expect the person claiming protection to relocate internally within his country of origin. In answering that question, the decision maker must have regard to all relevant circumstances of the person claiming protection and his country of origin, as explained in Januzzi and AH Sudan, and there's quotations above in the judgment of paragraphs 11 and 12. This has been described as a holistic assessment encompassing all relevant considerations. Having considered all the circumstances, it must decide whether it would be unduly harsh and so unreasonable for the person to relocate internally within his country of origin. Now, the Court of Appeal found that the Upper Tribunal had carried out its task properly in terms of the assessment of internal relocation. Paragraph 28 is quite helpful, actually, when you're addressing internal relocation within your skeleton argument. Set out all those material considerations that need to be looked at in the assessment of internal relocation. And perhaps if you're challenging a tribunal judgment where they've said the client can internally relocate, have they carried out, the tribunal, a proper holistic assessment encompassing all relevant circumstances? In terms of issues of burden of proof it didn't really need to be determined because they found the Upper Tribunal had properly applied the test. But Lord Justice Lewis said this: my view is that as a matter of principle, consideration of internal relocation is an aspect of whether a person can establish that any fear of persecution is well-founded within Article 1A of the Refugee Convention. If that is correct, then strictly the burden is on the appellant to show a reasonable degree of likelihood that internal relocation would be unduly harsh and so unreasonable. In practice, however, decisions of internal relocation are unlikely to be determined or influenced by considerations of the burden of proof. The appropriate approach is that set out in Januzzi, A.H. Sudan, and S.C. Jamaica. The question the decision maker has to decide is whether it would be unduly harsh and so unreasonable for a person to relocate internally within his country of origin. That will involve the decision maker considering all relevant circumstances. In the light of that view, the decision maker forms of the circumstances, the decision maker will then decide whether internal relocation is unduly harsh, bearing in mind that it is a high threshold to cross. Just as a side note, don't forget, obviously some appeals now are pre-NABA, some are post-NABA. Is that helpful decision from Judge Bruce from last year, JCK, which goes through the varying standard of proof in the Brit, and she breaks it down into 5 questions in terms of asylum cases post-NABA. So do have a look at the JCK reported case. Revocation of protection status. Now, don't go to sleep at this point if you don't do protection claims, because this case also has a bearing on procedural unfairness. So, the central issue which the Court of Appeal decided in this case is whether it was unfair of the tribunal where they identified a fundamental jurisdictional error in the determination of the FTT, which had not been the subject of argument. Should that have been brought to the attention of the parties, and should they have been given an opportunity to make submissions on it before deciding the appeal? And Lady Justice Andrews says this: having now heard full legal argument on both sides, I've concluded that the Upper Tribunal was not only entitled, but was obliged to consider the point that it did, and that it reached the correct decision. However, for reasons which I shall explain, I consider the Upper Tribunal should have drawn the point to the attention of the parties and at least invited short written submissions on it before making its final determination. Whilst procedural fairness does not inevitably require giving a party a right to be heard on a point which a court or tribunal makes of its own motion, it would rarely be appropriate to proceed without doing so. Now, in this case, the outcome wouldn't have made a difference. This was concerning the revocation of protection status. So paragraph 5, they set out section 84 of the 2002 Act. You've got 84.1, which deals with a refusal of a protection claim, but there are different grounds in relation to the revocation of protection status. That's set out in 84.3 of the 2002 Act, and it must be brought on one or more of the following grounds: that the decision to revoke the appellant's protection status breaches the UK's obligations of the Refugee Convention, or the decision to revoke the appellant's protection status breaches the United Kingdom's obligations in relation to a persons eligible for a grant of humanitarian protection. This was an individual who claimed to be a Saudi national, had been granted protection status. It turns out she was Yemeni, and the Secretary of State made the decision to revoke. In the first tier tribunal, the PO made a concession that it would breach Article 3 for her to be sent to Yemen. So the first tier tribunal allowed the appeal on the basis of the second of those grounds in relation to humanitarian protection. But then the Upper Tribunal overturned that, effectively saying, well, that was not the relevant question. Paragraph 47 of Lady Justice Andrews: in the present case, as the Upper Tribunal rightly identified, the target of the appeal under section 84.3 is the decision to revoke the appellant's protection status. SA was granted a protection status as a refugee on the basis of a claim which was premised on various key facts misrepresented by her to the Secretary of State, as well as to the FTT, which heard her asylum appeal. These were not confined to the question of her claimed nationality, but included the entire fictitious history on which she had relied as giving rise to the alleged risk of serious harm on return to Saudi Arabia. Revocation of her refugee status was mandatory under the immigration rules once it was established that she had obtained it by material and dishonest representations. And that effectively not only answered the question under the first ground, that answered the question in relation to humanitarian protection. The question was not whether removal would breach those obligations, as it would have been on an appeal under 82.1 to grant a refugee status. Removal is not automatic consequence of revocation, and in the present case, SA still has ILR, though the revocation of a protection status would leave her open to the SSHD exercising discretion whether to curtail or cancel it. So the fact that there was a concession that she couldn't go to Yemen wasn't relevant. The fact was her claim was based on a fictitious basis, so that was sufficient under both revocation grounds, and issues about return to Yemen were for a different occasion. I'm conscious of time. I just want to flag up a nationality case. This is the first case, APD, on the relatively new Section 4L of the British Nationality Act, which was the special circumstances provision. If an application is made for a person of full age and capacity to be registered as a British citizen, the Secretary of State may cause P to be registered as such a citizen if, in the Secretary of State's opinion, P would have been able to become a British citizen, but for historic legislative unfairness, an act or omission of a public authority, or exceptional circumstances relating to P. This individual was refused on the basis, well, you don't come within the section because your refusal doesn't stop you from applying for citizenship in the future. So the Secretary of State's position before the court was, well, in order for Section 4L to apply, you've got to be definitively shut out. In the claimant's case, she can apply at a later date. The claimants challenged that. But the second reason in the decision was, well, in any event, the causation test, the but-for test, is not satisfied. There was an argument about when her husband was given permanent right at a later date than he should have because of a wrong interpretation in relation to dual nationals and the Lowndes case, for those who know. But the Secretary of State said, well, there was too many uncertainties to say that caused somebody to miss out on citizenship. The High Court agreed with the claimant and said this section doesn't have to definitively shut you out of citizenship. You can still apply, even if you're entitled to apply in the future. But they agreed with the Secretary of State in respect of the causation point and found that there was no irrationality or illegality in the assessment of causation. So the Secretary of State's error in relation to their application of 4L wasn't material given the causation point. Because of time, I'm just going to leave that there because it's quite deep waters, but do go back to it. Let's go and look at Article 8. Chikwamba, precariousness and family life. Over recent years, we've seen the erosion of the Chikwamba principle. There was a case in the Upper Tribunal called Eunice. Then there was the recent case of Alarm from Lady Justice Elizabeth Lang. She takes it up again in the case of Butt and agreeing that the Upper Tribunal was right that the first tier made an error of law in allowing the appellant's appeal in reliance on Chikwamba. Chikwamba is about proportionality of making somebody go back and apply for entry clearance. She says this: I do not accept A's assertion in paragraph 16 of his skeleton argument that there is still confusion after the decision in Alarm about the status of Chikwamba. Alarm decides that the only case in which the reasoning in Chikwamba is potentially relevant now is if the Secretary of State expressly refuses leave to remain solely on the narrow procedural ground that the applicant must leave the United Kingdom to apply for entry clearance. And even then, so even if it does apply on that narrow ground, it is necessary for the FTT to make an overall assessment of the strength of the applicant's Article 8 case. This case is not such a case. The reasoning in alarm leaves no scope for A's argument that Chikwamba applies if the effect of a refusal of leave to remain amounts in substance to a requirement to leave the United Kingdom and apply for entry clearance from abroad. She went on to say at paragraph 84, my reasoning and in alarm, which is in part based on the express reasoning in Chikwamba and in part on the reasoning in Hyatt, does not leave any room for the argument that a refusal of leave to remain is in substance a requirement to leave the United Kingdom to apply for entry clearance and automatically attracts the other reasoning in Chikwamba. It is in any event clear from Chikwamba that an express requirement to leave and apply for entry clearance is not disproportionate in every case, as the strength of the Article 8 case will depend on the facts. The reasoning of the Upper Tribunal in Chen does not help the appellant's arguments. She accepts she didn't refer to Chen in alarm and considers Upper Tribunal Judge Gill's decision in Chen in this case of but. But it really leaves, sort of, I called it the slow death of Chikwamba. It is, maybe I should have said, the final nail in the coffin of Chikwamba, because how often do we see a case where the only basis of refusal is the express requirement to leave and apply for entry clearance? I may have had one recently when an American entered on a visitor visa with his family who were Brits. He couldn't get within Appendix FM because he was an American national. Sorry, because he came here as a visitor. So they were saying, go back to the States and apply for entry clearance. That may be a sort of situation where Chikwamba still has a bite, but very rarely can I see Chikwamba now getting off the ground in any cases as a result of but. Lady Justice Elizabeth Lang also looked at the case of Arshad, 2025 EWCA Civ 355, about an overstayer who had relationship with his sister and her 3 children, like an uncle in the family. And she gives clarification in this case of the concept of family life and the concept of precariousness. In terms of family life, it was accepted that family life was engaged in this case. But she says just the engagement of family life is enough. You've got to look then at the quality and the nature of the relationship. Look at the middle of paragraph 118. The family life of parents who live together with their young children is at the core of family life. It is self-evidently entitled to greater weight in any proportionality balance than more distant relationships, such as the relationship between adult siblings who have spent periods of their adult lives in separate households, and the relationship between a resident uncle and young children. This is this case, who have both parents living at home. The fact, therefore, that a fact finder has classified a relationship or relationships as family life for the purpose of Article 8 is only a starting point. It is necessary to understand the nature and quality of the relationship before it can be weighed against other considerations. So perhaps in our arguments, we need to make sure we address the nature and the quality of the relationship, because just because Article 8's engaged doesn't mean every Article 8 relationship is of equal weight. She also then, relying on the case of Lal, and I've seen her in a number of her judgments refer back to that case of Lal, so probably worth revisiting, about the spectrum involved in the word precarious. There's a huge difference in the different kind of precariousness. Have a look at what she says there, and look at the final bit I've highlighted. I also accept Mr. Tabori's submission that the cases show that the fact that a family relationship has been formed and or developed when a person is in the United Kingdom illegally is relevant to the weight which should be given to that relationship in the assessment of proportionality. That is so whether the point arises outside the scheme of Part 5A of the, it says 2001 Act, that's a clear typo in the judgment, should be 2002, or within that scheme, as Rupiah illustrates. I'm not going to touch on AA Morocco in any length. It's one of those cases that had bounced up and down, and the Court of Appeal were critical of the Upper Tribunal. But if you're doing a health claim, there's a really helpful summary of the law in relation to Article 3 health claims, Article 8's relevance in health claims, and if you're arguing sort of health as an aspect of very significant obstacles to integration, look at paragraphs 23 to 43. I've got 4 minutes left, so just a few quickies for you. In terms of COVID exceptional assurances, there's the case of Surangan. This was somebody who applied late for an exceptional assurance. They were given a short assurance and then applied as they were refused an exceptional assurance, just given a short assurance, applied as a skilled worker and said, well, you should overlook all my disregard all my overstaying. That was refused, and the Court of Appeal agreed in relation to that. And they distinguish within the exceptional assurance policy between regularized overstaying and unregularized overstaying. And obviously, Sirangan wasn't somebody who applied promptly, but I think he applied after being an overstayer already for 9 months. So if you've got people trying to rely on previous exceptional assurances to disregard periods of overstaying when making an application, have a look at Sirangan and the different approach between regularized and unregularized overstaying. Very sad case in relation to revocation of deportation order. That was Tomlinson. He was deported, married a British citizen, moved to France with her. She ended up coming to the UK for medical reasons. He wanted to return with her, so he applied to revoke his deportation order. That was successful on appeal. He wasn't granted entry clearance, so he applied for entry clearance, and that was then refused because of his conviction, even though he'd won his revocation of deportation appeal. He judicially reviewed that. That was expedited because of his wife's illness, but she gave birth to a son in November 2020. Well, sorry, she gave birth to a son and then in November 2024 died soon after. And Mr. Tomlinson and his son remained in France. He had JR'd the decision. The Upper Tribunal refused and said, well, the FTT's decision was only in relation to deportation. This is an entry clearance refusal. And in any event, you've got an adequate alternative remedy. The Court of Appeal weren't impressed with the Upper Tribunal. They disagreed and effectively found, well, there would only be one answer in the entry clearance, and that would be that it should be allowed because of the matters that had already been decided in the revocation decision. And they disagreed and found it deeply unattractive, the approach of the Upper Tribunal in the JR about the alternative remedy, because it wasn't an alternative remedy in terms of the Wensbury reasonableness within the decision of the Secretary of State. I won't go on with that. It's worth looking at actually about alternative remedies are primarily in judicial review, an issue at the permission stage. They also say there was a contradictory approach, paragraph 81 by the tribunal. They allowed the appeal, but very sadly, because she had passed away, couldn't make the declaration that he was entitled to entry clearance. I'm conscious of the time, so just as a final wrap up in 1 minute or less, new reported cases of this year. We've got a helpful gurung. This goes through the correct approach to the interpretation of Home Office policy. So if you're arguing about how a Home Office policy should be interpreted, look at the head note of gurung. I've highlighted the key bits for you. EK is about the withdrawal of decisions under the Upper Tribunal rules, and where the sort of default position is usually consent will be given, but the tribunal can refuse consent in the appropriate circumstances, and an abuse of the tribunal's process is a powerful factor which they will consider. Appendix representatives of an overseas business in terms of establishing a branch rather than the takeover of a branch. If you're doing Appendix ROB, look at this case in terms of the taking over is not going to satisfy. The requirement is for the UK subsidiary to be wholly owned, is engaged at the point of establishment, not at the point of application. And KM Nigeria is about ECAT stay and when that is necessary. It's 2 o'clock on the dot. Here's my link. Thanks for bearing with me. I hope you're still all alive. Back over to you, Finn.
Thank you very much, Adam, and thank you to everyone for joining us today. Yeah, sorry we didn't have any time for questions at the end. As a reminder, the slides and a recording of the webinar will be sent over tomorrow. This afternoon, you should receive an email asking to rate the webinar out of 5 stars. If you have enjoyed, please do leave feedback and any suggestions for future topics. We don't have any webinars lined up for the rest of the month, but do keep an eye out on the upcoming free webinars section on the DG Legal website for any new webinars we have planned. And you can also sign up using the link on our website to receive training course updates. We do have lots of premium courses coming up, including sanctions training, SRA accounts rules, and our COLP course. Thank you again for watching, everyone, and thank you, Adam. Have a good afternoon, everyone.
Thanks, everyone. Bye-bye.
Cheers. Bye-bye.